I'd like to talk next about the proper use of provisional applications and how to turn a provisional patent application into a utility patent application by properly claiming back to the priority date of the provisional application. Now, a lot of inventors think that they can just file a provisional application and they're going to have no problem running into an investor or indeed a buyer of the patent rights entirely who's going to spend millions on a provisional application. That has almost never happened, and the reason why is that the main goal of a provisional application is to buy the inventor a year of grace period, during which time the inventor can seek out investment, maybe try to sell the patent rights outright. But for most inventors, that year grace period is spent tweaking the invention and trying to improve upon it to the point where when the utility patent application is filed, the inventor has truly a really good idea of what the invention is all about. So, how do you use a provisional properly? Well, there are three main things you need to remember about provisional patent applications and how to use them. The first is that you've got to make sure that you file the provisional patent application before you disclose your invention. Now, what is a disclosure? Well, if you look at our prior art searching video, you'll see all the things you can do to create prior art, or other people can do to create prior art. But you as the inventor have to be aware that you too can create your own prior art that can later count against your ability to get a utility patent on your invention. Now, how do you create your own prior art? Well, one of the most egregious ways is the inventor goes to trade shows before they have a provisional application filed. They disclose their invention at the trade show, and then they wonder later on why people at the trade show are pointing out to them that they've created their own prior art that can count against their patent application. So, if you know this one trick, you'll be able to avoid that problem. File the provisional first, then disclose your invention second. So the first thing is it's important to file the provisional before you disclose your invention. The second thing is the provisional has to be well written. Now again, the way that most inventors do this is they file the provisional, then they disclose their invention, and within a year of the filing date of the provisional, they file a utility patent application. The utility patent application then claims back a priority date of the provisional. So if the provisional is well written, the examiner, when the utility application comes across his or her desk, will look back at the provisional and say, yeah, when the inventor had this provisional prepared, the inventor had in his or her mind a pretty good idea of what this invention was all about, so I'm going to give them the priority date. And in that case, the utility patent will actually have a priority date of the provisional application. However, if the provisional was written very poorly, and the examiner looks at it and shakes his or her head and says, you know, I'm looking at this provisional and I really can't tell whether the inventor really had in his or her mind the full idea of this utility patent application when the provisional was prepared, the examiner has the right and indeed the obligation to deny the priority date, in which case the utility patent application would have the priority date of the utility patent application. Now, if you disclosed after the provisional, you are still within the 1-year grace period from public disclosure until you have to have a patent application filed on your invention. If, on the other hand, you disclosed before the provisional, you're running the risk that if the provisional is found to be defective, that you have created your own prior art that can count against your ability to get a patent on your invention. So the second thing is, got to have a well-written provisional. The third thing is you have to file the utility patent application within a year of the provisional and claim back the priority date of the provisional. Now, a lot of people think that you can just keep tacking provisionals, file a provisional at the end of the year, file another provisional. Well, you can do that. You can file 20 years of provisionals one after the other, but your utility patent can only claim back a filing date of a provisional filed within a year. So if you file 20 years worth of provisionals and then file for utility patent protection in the 20th year, your utility patent will only claim back the provisional that was, say, filed in year 19. Now, if you've been going to trade shows all those 20 years, you have created 19 years of prior art before the provisional filing date that becomes your utility filing date. So you've effectively shot yourself in the foot. So again, the three things are: file the provisional before you disclose, have a well-written provisional, that can later on support a utility patent application. And third, make sure to file the utility patent application within a year of the provisional. If you remember those three things, you'll remember the really important aspects of the proper use of provisional patent applications.